Let me welcome Eryn Hurley, NACo's legislative director. And for those that are either listening now or at a later time from our website, NACo has graciously agreed to provide Florida Association of Counties monthly federal updates just to keep us apprised of federal issues that are important to counties. I also asked, and she has agreed, that every other month that they also provide a policy spotlight issue. And so that's what today is. So she provided the federal update last week with Jeff Scala from our office. And now this week is the first time we've asked them to provide a policy, I don't want to call it a deep dive, but just a highlight of important issues for us. And so I emailed her and asked if we could do it on WOTUS, since the Supreme Court has just ruled on this very complicated, bizarre issue. And Eryn, I thought that I understood this at a high enough level where I felt confident. And I still think so, because one of your colleagues has been bringing this issue up and summarizing it to the membership for several years. And so what I did yesterday afternoon was go through a lot of the NACo blogs and summaries, and then I found a YouTube video of a bunch of lawyers talking about this stuff, notwithstanding, but excluding the most recent Supreme Court decision. So I thought I understood it, and then I walked away even more kind of confused as it relates to the court's decision and its impact on counties. I know it'll have a significant impact on private property owners. It'll have significant interest to a lot of environmental groups. But can you, at a very high level, just talk about waters of the U.S. and some of the recent court cases that led us all the way up to the most recent one? And you don't have to get too deep if you don't want to, but just if you wouldn't mind just bringing us up to speed. Thank you.
Yeah, absolutely. Thanks, Eric. And hi, everyone. Again, Eryn Hurley with NACo. So I'll just very, very briefly start with a background of WOTUS and kind of like how we got here, and then we'll get into the weeds of the Supreme Court case Sackett versus EPA. So Waters of the U.S. or WOTUS is a term used that's actually under the Clean Water Act to determine which waters and their conveyances fall under federal jurisdiction opposed to state permitting authority. So what that ultimately means is that it establishes a basic governance for pollution of the nation's surface water. And it also prohibits the discharge of certain pollutants into navigable waters. So because the waters of the U.S. isn't actually defined under the Clean Water Act, what has happened is that the U.S. Environmental Protection Agency and also the U.S. Army Corps of Engineers have had the responsibility of actually defining what waters of the U.S. is under the Clean Water Act over the last 40 years or so. So how this all started was that back in the 1980s, EPA and the Army Corps, they defined WOTUS to include all waters and wetlands that use degradation or deconstruction that could affect the interstate of foreign commerce. So that's pretty broad. Since that definition came out in the 1980s, what has happened is that there have been multiple Supreme Court cases throughout the years. There was one back in 1985 that upheld that wetlands are adjacent to other jurisdictional waters that are subject to the Clean Water Act jurisdiction. There was a more recent one in 2001 that ruled against the Army Corps' interpretation of what WOTUS is and held that the use of like isolated ponds by migratory birds did not actually mean that those bodies of water were subject to the Clean Water Act jurisdiction. And then the most recent one actually up until Sackett versus EPA was back in 2006. So what happened there in that court case is that there were actually two different standards were established. One was by Justice Scalia, the other one was by Justice Kennedy. So the first standard was that the waters of the US includes only relatively permanent standing or continuously flowing bodies of water. So this like includes streams, rivers or lakes, or also wetlands that have a continuous surface connection to other waters considered waters of the US. So that is, a pretty expansive definition of waters of the US. And then the other standard that was set was wetlands should be considered on a case-by-case basis to determine whether they have a significant nexus to traditionally navigable waters. So at the same time that all of this is happening, there were multiple definitions coming out from EPA and the Army Corps of what is defined as waters of the US. So back in 2015, the first definition that actually WOTUS was redefined for the first time since the 1980s. And that actually immediately faced legal challenges. That was under the Obama administration. So because of those legal challenges and in the different circuit courts, what happened was that definition was not applied to all of the states in the country. So what happened is that in 28 states, the pre-2015 regulatory framework, so that pre-2015 executive order, that was only in effect in 28 states. And then the new rule was in place in 22 states. Then in 2020, the Trump administration repealed and replaced the 2015 rule and released its own definition of waters of the US. And then in 2021, or most recently, the Biden administration released another executive order to trigger a review of the 2022 rule and release their new rule in 2021. So that brings us to where we are today when the Biden administration rule went into effect on March 20th of 2023. Some background there, after the actual rule went into effect, what Congress did is that they passed the Congressional Review Act, CRA for short, which ultimately would pretty much like defer the rule or rejected the rule itself. So folks were kind of like in limbo for a little bit until this Sackett course came about, which is what we'll talk about today. So what the Sackett versus EPA is that it really wanted to determine or address the split between that Supreme Court case in 2006 that I mentioned earlier. That was the title of that court case was Rapinos versus United States. And so what it did was that it wanted to determine that. So again, just as a recap, in that Rapinos case, Scalia provided a narrower definition of WOTUS, limiting it to that relatively permanent standing or flowing bodies of water. And then Justice Kennedy found that wetlands with a significant nexus to navigable waters are considered WOTUS. So more expansive. Yeah.
Can I interrupt you just
Yes.
real briefly?
Yeah,
With respect to NACo's historical position on that case, would you say it was more in favor of what Scalia had defined?
Yes. Okay. So NACo wants a narrower definition, especially because the fact that, it just with the expanded definition, it really causes a lot of complications, especially around infrastructure projects. So that was something that NACo, back when the 2015 Obama administration definition came out, NACo did submit comments in response to that, saying that we did have a lot of concerns with the more expansive definition. And then the Biden administration definition was definitely kind of a midway between the Obama administration definition and the Trump administration definition. So it was a middle ground. We definitely did still have concerns with that definition. But to answer your question, yes, the Scalia definition has a more narrow, which NACo was more supportive over.
All right, thank you. Sorry to interrupt.
Of course, no, you're fine. And so why the Sackett versus EPA case actually came to be, it was a legal battle that began in 2008 when an Idaho couple, their last name is Sackett, they were trying to build a house on an empty lot near a large lake and began actually backfilling the property. The Sacketts, they actually received a notice from EPA to stop their work because their lot contains wetlands protected by the Clean Water Act, which again, at this specific time, it didn't allow the discharge of pollutants, including like rocks and sand, into those navigable waters. So ultimately, the Sacketts ended up suing and then appealed after the Ninth District Court applied the more broad significant nexus test to uphold EPA's judgment. So ultimately, that is why this ended up going to the Supreme Court. So what's the kind of end or the conclusion of the Sackett case? What ended up happening is that it reversed the Ninth Circuit in favor of the Sackett. So it once and for all rejected that significant nexus test to narrow the reach of federal Clean Water Act protections. So what this means under the majority opinion of the Supreme Court justices, whether the Clean Water Act can regulate a wetland depends on if it's adjacent to a waters of the US. That is a practical matter indistinguishable from WOTUS, meaning that ultimately what happens is that there has to be some sort of continuous surface connection to a navigable water. So what that means, like, I know there's a lot of words happening, but just like to put it more plainly, so the Clean Water Act will only apply to wetlands that blend or flow into neighboring navigable waters. So it's, again, a much narrower description. So ultimately, it rejects that significant nexus test, which would have made the definition much more broader. The significant nexus test makes the definition more broad. The Supreme Court rejected that test. And so that brings us to where we are today, which is a little bit confusing. So this decision really does not actually provide the full clarity that NACo and counties were really hoping to, because it's difficult to determine whether the new test will insulate any sort of like county-owned infrastructure from WOTUS coverage, and it remains to be seen how the federal government will ultimately rewrite its regulations to comply with the ruling. However, because the test that the court adopts limits the definition of WOTUS, it seems likely that at least like some infrastructure that had previously been swept under the broader definition may be excluded. So, and taking that a step further, because the Supreme Court ultimately rejected that significant nexus test, we know that the EPA is going to, or the Biden administration is going to come out with a new definition of WOTUS in the fall of 2023. They kind of knew that this was going to be the outcome of the Supreme Court. So they were already kind of on their way to rewriting a new rule. But the caveat here is because that significant nexus test was rejected by the Supreme Court, whatever new rule that EPA and the Army Corps come out with cannot include that. So really, no matter what, it's likely going to be a narrower definition of waters of the US, which ultimately is beneficial to counties. We are a little bit in a limbo period right now, though, because of this Supreme Court case, and we've actually been trying to work with the EPA to have a full understanding now of, like, while we're in this waiting period until the new rule comes out, what's considered a WOTUS versus not. EPA themselves are actually still trying to work through what that actually means. So we're pretty much talking to them on, a weekly, if not daily basis to get that clarity. So of course, we'll provide you all with a very, very detailed update once we do hear more from EPA, but they are still, working through that. But that's kind of where we are today. I think the big key takeaways is that, right now, NACo is really, really pushing for clarity around this issue since we haven't had clarity for so long. And that no matter what in the fall, once a rule is released, it's not going to include that significant nexus. So there will be a narrower definition, most likely for WOTUS, which ultimately will very much so benefit counties and any sort of infrastructure that we're responsible for as well.
And Eryn, I may have just missed this because I was looking down at some notes, but on infrastructure and other sort of conveyances that were previously under the Clean Water Act, based on, the significant nexus test, there was permitting. What's the status? What would be the status of those going forward?
So for those infrastructure projects, because the court adopted the limited definition of WOTUS, it does seem likely that at least some of that infrastructure that had previously been swept under the broader definition will be excluded. Okay. So even under this like limbo period. So again, since we're still waiting for EPA to release like additional guidance of where we really are, we're not 100% positive, but it does seem likely moving forward that, again, those projects would be excluded from, what's allowable versus not.
And from just like an annual compliance standpoint, or monitoring and that sort of thing.
Yeah.
So that was fantastic. I can't believe you went through all of that history. Anyway, but I think you provided what we were observing yesterday in some of the documents that you produced, that it's not specifically clear that we're in a better position, but all indications are based on the standard that the court ruled on, that it looks like it's in our favor.
Yes, absolutely.
But I have sort of just an outside question. Why? So the rule, I guess the one in 2020 was subject to the Congressional Review Act. Is that the one, the CRA?
So actually, the 2021.
2021.
Yeah, under the Biden administration, because what happened was that it did go into effect in March of this year. And so, especially given that the House flipped after the midterm elections, ultimately, they were able to pass the Congressional Review Act, which ultimately, yes, it did pass. So it does demonstrate that there is bipartisan support and hesitation around the implementation of that type of definition. It didn't change all that much just because the SACA case was so soon afterwards. But that's all to say, Congress did pass the CRA as it relates to the 2022 Biden administration definition.
So why hasn't Congress just gone in and defined what waters of the U.S. means in law? Why stretch this out for 40 years?
So I think it's easier said than done to actually go back to the law itself, like the Clean Water Act, and rewrite the statute for waters of the U.S. and try to gain, I think, consensus around what that exactly means. And just given the fact that, I just think that it's easier said than done to try to alter such a significant piece of legislation like the Clean Water Act. I think there's I think a lot of stuff has changed since then when the Clean Water Act was actually written. And so I think they've just kind of defaulted to this like ongoing process with EPA and the Army Corps.
Yeah, it's amazing. Well, I don't know if there's any questions. We have Commissioner Starkey, she's chair of our federal committee, and then our incoming president, Commissioner Truex, are on. I don't know if they have any questions, but I would like to, if they want to raise their hand and we can unmute you. If you do have a question other than that, then we will probably conclude. There is a question. Chris, you're our moderator. I don't know if you can unmute Commissioner Starkey because she just raised her hand. And we're trying, Commissioner. And now, Commissioner Starkey, you unmute yourself. There you are. Welcome.
And sorry if this is an ignorant question, but are wetlands included in this at all?
That's for you, Eryn.
Yeah, no. That's so for this, what ends up happening is that hold on, let me just think about this. So with that, I don't believe wetlands are actually ended up being included in that. Let me just double check, but I'm pretty sure they don't, because again, like with the wetlands, how they are assumed to be connected to like other bodies of water is that significant nexus test.
Yeah, because you said it had to be connected to a navigable body of water, and wetlands, you know, typically connect to maybe to a recharge for an aquifer, and that's not navigable. So
Yeah, so for this one, like, so pretty much what it did is that it ruled against Justice Kennedy's standard back in the 2006 case, where it found that wetlands with significant nexus to navigable waters are considered WOTUS. So what this court case does is that it does reject that definition or that standard.
okay, thank you.
Commissioner Truex, no hand up, no question. So with that was great. Eryn, thank you so much for coming on and tackling a very complex issue. My sense is that we'll get an update at the annual conference in Austin, and we look forward to seeing you and your team there. And thank you again for coming on.
Yeah, absolutely. Happy to. Thank you for inviting me.
All right. See you soon.
All right.